I'm delighted to be here again. As for those of you who remember, we made a speech at the last NANOG giving preliminary results of this work that we're doing, which is being funded by the National Science Foundation. And I should say a great thank you both to Andrei and Artyom for actually setting up this presentation so well. As Andrei pointed out, there are non-technical dimensions, whether collective action and otherwise. The whole motivation of this project is comments from actually previous NANOGs from members of this community and other places that there are legal barriers that were retarding the adoption of RPKI, and that we needed some independent study of someone with sufficient technical expertise and legal expertise to be able to solve this problem. In this sense, I'm a bit of a unicorn in the sense I have both appointments in computer science and in law. And so they tapped me to do this and asked me to explore this and to really understand the dimensions, take a deep dive into the interaction between the legal aspects and the adoption methods to see what recommendations we can come of possible changes to smooth through those issues. And I have to thank Artyom too for actually setting the stage very nicely. He talked about the tragic story about RPKI and talked about how he's unduly pessimistic at the risk of being the Pollyanna that he is not. I'm going to tell you an optimistic story, which is this has been a really remarkable year for RPKI in many, many ways. So, for example, many of the large providers who are players in this space who have been studying and watching RPKI for a long time, we've seen a series of announcements of very active involvement in the RPKI world that's going to actually start unlocking the benefits as more people deploy the technology. As most of you probably know, Cloudflare is actually issuing ROAs and is actually doing a certain amount of filtering. NTT, well, we'll come back to that in a minute. The big news that circulated the list, and Nimrod will talk about later in one of his lightning talks, is AT&T has begun actively filtering routes based on RPKI-based information. The excellent presentation by Manners. Manners has incorporated some type of route validation into its requirements. It's agnostic about particular technologies, but in candid conversations with Manners, as of now, there are no alternative technologies on the horizon. There's an announcement that Google has made that they have actually begun flagging routes for some time and expect to begin actively filtering routes later this year. And what's fascinating to me is there was a workshop co-led by Doug Montgomery at NIST, Martin Levy at Cloudflare, and Job Snyders at NTT about yesterday or Sunday about how to deploy RPKI, and at which point I learned that, in fact, Cloudflare is deploying a new validator software called OctoRPKI, which all of us know is a robust set of software options, is a very welcome part of the space. I skipped over the NTT aspect. This is a fairly novel idea where they're actually using route origin information, incorporating that into IRRs for active route management. And so these are really interesting developments that have helped take the RPK off the back burner where it's been for so long and an issue on people's agenda and really pushing it to the top of the agenda. And so I think that there's a lot of reason for optimism today based on the level of interest, both at the last NANOG and this one. There is a bit of a puzzle, which is, or one of the motivating problems. There's a general problem with RPKI adoption, which is it only takes hold when a sufficient number of other people are actually signing routes and filtering routes. But there's, independent of that, a different problem, which is there's a differential level of adoption in the RIPE region than there is in other parts of the world. In particular, RIPE is by far the strongest, LACNIC is the second, and ARIN actually at one point, based on the data I showed you at the last NANOG, actually the percentage of the routes that have been signed, the origins that have been signed was actually declining for a brief amount of time. And actually it's bumped back up, but it's still flat to where it was about several years ago within the ARIN region. And so here you start to realize that there may be something, you try to look for regional differences in how they approach it as a basic research methodology. That's the signing side. On the filtering side, what we're discovering is that Ben Cartwright-Cox has done some nice studies that discovered that 80% of the people who are engaging in filtering are only using 4 TALs from 4 regions and have not deployed the ARIN TAL. And so there seems to be, and there's other data coming out of APNIC that sort of draws similar conclusions. So a lot of the motivation, part of it is to try to facilitate RPKI generally, but to try to study the problem to understand if there's something unique about the ARIN situation and the legal context in which it operates that may explain some of the differences, given that that might not be as uniform. And so what we've seen is that's the basic idea. We made this presentation earlier based on the input from this community, and I have to really thank this entire community and ARIN in particular for being involved in a very active dialogue to really understand this problem. And I'm actually really heartened to see that a lot of the discussions are moving past law and to the real operational issues that are going to lie at the heart of the ultimate success or failure of securing the internet through RPKI. We published a report to the NANOG list on December 31st of this year. This will make all of you cringe, but lawyers are pretty easy about this. It's 34 pages, warning in advance. But it goes through the issues, hopefully in a way that is, we're told, is fairly accessible. And that, in fact, there's a lot of movement already in terms of cleaning up some of the clauses in the legacy RSA, cleaning up some of the action, making broader use of the prohibited conduct clause, which we talked about last time, which frankly have already been incorporated into ARIN's work streams and processes, and we're very encouraged by their active engagement in this and their real desire to try to make this work, RPKI deploy better. So one of the big issues that we have identified involves something called the relying party agreement. These are people who would like to use the information in the libraries to engage in filtering. One of the interesting aspects is to access the trust anchor locator for ARIN. The current design requires you to go to the website and click through on the TAL itself with the terms of use prominently displayed on that page. And the reason that works, and that in effect prevents validator software from being distributed with all 5 TALs, to get to the ARIN TAL, you have to click through and actually acknowledge that you've been on that page and implicitly acknowledge the terms. And that is a distinctive change, but is an artifact of American law that unless you have something in the visual field of the person who's accepting it or using the software, you cannot have what would be considered a binding contract. So the interesting question is on 2 approaches: do you need a binding contract? And one of the interesting problems that we've run across in the discussion is that there are 2 solutions. One is to abolish the contract altogether and simply allow the risks to fall where they may, or you can actually have a contract. And what's interesting is by changing the environment and putting RPKI now is becoming more a part of the active routing policies, or the way that operational routing procedures of operators like you, of the people in this room. This is a role that RIRs had not traditionally played, and there's a question about the proper bearing of risks. And one of the most interesting parts of the conversation that came out on Sunday was actually an active difference of opinion among operators about how to properly characterize a service like RPKI. One version is to think of it as you will, is an online, real-time, in-path function that you use to secure your system. And that requires constant validity and current updating. The other way is to think of it as a security feature that is separate and added onto the existing system that would be updated daily, maybe a few times a day, and not be as operationally in line. And that's an important distinction to draw between the 2, because the risks and what the technical requirements of the demands of putting something that's in line in real time are much higher. They'll require different service by every provider in the path. And it's a different conception. And one of the things that I'm hoping will happen on the operator community on the technical side is an active discussion of which of those models is really the one that operates. One of the things that we are pushing towards is actually there is an alternative about how you lay off risk, and we're going to present several of them. The current one is a blanket indemnification clause, which we regard as too strong because it's indemnification against any relying parties indemnify the RIR, or in this case ARIN, against any failure, and that includes failures that are on ARIN's end over which they can't control. A fairly basic legal principle is you should be responsible for things under your control, and and be honest, and the discussions with Aaron, I think they understand that and are very much engaged in a process to try to understand a way to redraft that. The other interesting alternative is to use an as-is disclaimer instead of an actual indemnification clause. So you don't actually make them indemnify against liability. You just say, I understand this, we take this product without warranties. It's what we do with open source and the like. Under US law, to do that, for that disclaimer to be valid, you need to have a contract. And so part of the argument is if we're going to shift from indemnification to an as-is disclaimer, under American law, there is a pretty strong argument that you would benefit from having some sort of agreement. This is just as a side-by-side comparison. Aaron does offers not just a disclaimer of warranties, but a requirement, the relying party agreement requires a duty to indemnify, defend, and hold harmless. And it applies to all actions taken by any party, not just the ones by you. This contrasts with AFRINIC and LACNIC, which have no agreement whatsoever. APNIC has no agreement, but has online terms and conditions, which under certain areas of law would create a contract. It includes indemnification, but not defend or hold harmless. And the right NCC has online terms and conditions, no actual contract, but only as a disclaimer of warranties, no indemnification, no hold harmless, and no duty to defend. And so we have a difference here, and we're looking at different ways that could work. It's interesting that for many people, one of the great thoughts I have is we are concerned about RSAs and relying party agreements. What we're starting to see is that these indemnification clauses are used in other places, on other agreements with Aaron, including RSAs, and even for people who are in the legacy space. If you have an IPv6 address, you've got an RSA. So it's hard to understand exactly causally how big an obstacle this specific one is. Our suggestion is to take to keep the contract, but embody in it to an as-is disclaimer of warranties that allows everyone to understand the product, and with proper disclosure of what the technical requirements and availabilities are, which is part of the conversation that started to happen on Sunday. That can actually work as a very effective way to move us through to a solution where RPKI is more broadly adopted. And this is really an interesting question, a broader question about the community needs to discuss in risk management, is that if it is a work stream that you want to be available and redressable within an hour or minutes, that requires a higher degree and a different kind of technical support. And if that's something that this community wants to do, they're going to have to discuss ways to manage the risk and to fund the resources it's going to take to make that possible. It's interesting, in the Sunday workshop, many people, the concern was not being able to get the problem addressed immediately, but just from a pure operational standpoint, they needed to log errors with Aaron. And even if it wasn't going to be redressed for hours or even a day, that would be fine. They just needed the person in the operator to get it off their work stream and put a flag or a ticket in someone else's work stream, and they can just wait for it to be cleared, which is sort of an interesting intermediate position that simplifies the operations on the operator side, but creates a much less onerous service responsibility on the people who have to make sure RPKI is functioning properly. What's really encouraging is the idea of a new validator software, the one being done by Cloudflare called OctoRPKI. One of the interesting problems, as we've said, is that as of now, all validators are only distributed with 4 TALs. It requires more to get to the 5th TAL and through the Aaron TAL. And there's actually really encouraging signs that Aaron has said in conversation that they are open to incorporating the approval of the RPA into the acceptance procedures for the validator software. So to the extent to which that's part of a click-through to make that work, you can probably get that possibly incorporated without actually requiring a separate click. One of the things we're actually exploring is enterprise-level agreements, so it's not every deployment. If an enterprise has an agreement to the RPA, you do not need separate agreement for every instance you want to stand up where you're deploying it to simplify this more and more. And we're looking into that to see if that's going to work. And in fact, what we have now is a possibility of new validators incorporating the 5th TAL and coming to some kind of agreement of this type that would allow we would achieve the goal we would all have, which is to have all the TALs distributed as broadly as possible, because unless they are, the entire security environment won't work in the same way we'd hope. Interestingly, there's a prohibited conduct clause in ARIN's current document, which they've already indicated a willingness to change. It actually prohibits sharing of RPKI information in any machine-readable format. As you know, any security world requires analysis of past results, as in not in real-time operations. And that technically is prohibited. ARIN has flat out said for machine-readable formats, for stuff that's not for operations, that's an easy a change they're willing to make to this clause, and have already signaled that willingness at the last NANOG. What's interesting more and more is the possibility, as exemplified by NTT's decision to use RPKI information to improve the IRR table that they maintain, that is going to begin using it in operational purposes, and there's currently explorations going on about appropriate ways to enable third-party providers or other people combining RPKI information with other sorts of information to create a better, more robust sense of what routing information about good routes. We all know that we have many sources of information of routes. They all are of varying provenance, varying quality, and the idea of using multiple sources and to combine together has the potential to create a much more robust and much more secure routing environment. So our recommendation is to look at these third-party solutions and some adaptation of the prohibited conduct clause in ways that will certainly facilitate the kind of research and analysis that's necessary, but in appropriate cases, in ways that manage the risk, try to find agreements and ways to allocate those responsibilities that allow the distribution of that information so that it can be provided by third parties operationally, or be combined with other information to improve the routing environment. One of the more interesting recommendations we make, and we're very interested in dialogue about this, is to the extent it's a concern about limiting the liability for this new service, a classic legal solution is to separate the functions of RPKI, that is the certificate registries and maintaining and assigning on a delegated basis, into a separate company, a separate entity that would stand alone and would allow, and the way the companies work is, if it's independent, the liability would not then flow to anyone else. This is got some potential, and we have a lot of experience of this in other contexts. It does require standing up a new organization, a certain amount of overhead, a certain amount of engagement from the community. This is something that actually, once we get to this stage, we can simply tee up the legal alternative and its benefits, but it's ultimately for the community of operators to decide, and the people on the internet governance side to decide if that makes sense, and if that's a solution that would like to be explored. And to do that, you could untether it from ARIN operations. In fact, it can insulate. There's a number of other concerns about having an organization, a particular type of organization, a US-based organization, in a position to deal with the certificate registries. There's some potential to create some additional benefits. There is some history about the reluctance to create a global TAL. That is a problem that many people immediately say, well, if you have a separate company, will it include just one ARIN's, the RPA functions? Should we consider other things? Many people wave history at me, and as I said on Sunday, there's a statement in law, there's nothing more revolting than doing something the same way, because we've done it that way since the time of Henry V in England. Where you don't, history is we got to get over that. And the thing is, we're in a very different situation today than we were then, and we should discuss, debate issues on their own merits about whether they simply make sense or not. And we have other precedents of examples where we've split them off. The other thing that's really interesting that came up in the manners discussion is the ability, the question, forgive me, I don't really have your name, but about whether to harness the power of the community to require from its partners that they comply with certain security hygiene problems. There's a certain amount of weak enforcement you can do, like by publicizing this and by making it visible and making it an issue. You can make this a lot stronger by building it into procurement requirements. And one of the things we're exploring is whether to build these RPKI capability much into federal government procurement requirements, much as we did with IPv6. But it occurred to us it's not just about government procurement requirements. Major companies, major providers, equipment manufacturers, everyone is in a position to include these things and insist on the people with whom you write contracts with some degree of verifiable compliance with certain security protocols. And this clearly could include RPKI. So we would actually say on a much broader level, there is a conversation that needs to happen here that about whether within your own organizations, whether we can solve the collective action problem, not just by having government procurement requirements, but by having people, operators require from their partners that they adhere to certain things. And the other thing is just to go back to the conversation. The last point I'll make is to go back to the conversation we had on Sunday. A lot of it is not about law, it's about operational practices. There have to be proper deployments. There have been outages of RPKI repositories, so having proper, we all know, I don't care how many nines you put on your reliability, there will be outages. Nothing works perfectly, and so there has to be proper procedures designed for failover that has to be done robustly, and in fact, these practices exist, but also, getting better information about availability, response times, practices. This is something this entire community is familiar with. Every time you've deployed a new technology, there's a learning process by which you understand what the real requirements are and the kinds of information and which is critical. And I was encouraged that on Sunday, what we really began to see is the beginnings of that discussion, and hopefully that will robustly continue on in the future. So this is basically what we're talking about. There is one other major sets of recommendations that we talked about, but we spent most of the time at the last NANOG talking about decoupling the question of signing the LRSA and the acknowledgement of who the residual rights holder to the IP address is from the question of RPKI. We've made recommendations on that, and they are currently for you to read in the document. So our reaction is, just to summarize, is the ability to distribute the validators with all 5 TALs would be a huge breakthrough. There seem to be some encouraging signs that some of the recommendations we're making may have the ability to crack that nut. The ability to adopt the RPA, possibly by adapt it to include an as-is disclaimer of warranties, to permit machine-readable use of RPKI information in appropriate circumstances, and really thinking about the non-member services pathway that RIPE uses to separate the RPKI issuance from actually the acknowledgement of signing the RSA. The new nonprofit is a discussion I would encourage us to have. And in fact, my hope is that conversations like the one we had last Sunday will continue, where the community can talk about practices, educate themselves, come to an understanding of how that's going to function. But most importantly is to keep the momentum going. I know many people have commented this has been discussed for many years without seeming to move forward. It seems like this is a moment where this really could make that kind of critical breakthrough, and I hope that we've been part of pushing it there, and I encourage the entire community to continue in that same direction. Thank you. If there's any questions. Please.
Matt Petak, I do thank you for that. The push for putting it in requirements, I think really is where the rubber meets the road in terms of money drives efforts. As much as we all might like to think we're making a great community, something's got to keep the machine running, and that's the money coming in. So if we can put these in as requirements, I think we're going to see a lot more movement happening on this. I really applaud your efforts on this. Love what you're doing with this. Thank you so much. This is really opening my eyes to a lot of the legal challenges here. Thank you.
Terrific. Thank you. John.
Yes, John Curran, Aaron. Of course, we're in receipt of this report, and I'd like to just thank Chris and his team from UPenn. We did spend quite a bit of time talking to them to make sure we were all in line about what the issues were and how they flowed into the resulting agreements. Aaron takes it very seriously. We've looked at the report. The board has directed a risk review, a whole review of the report, its recommendations, the risk profile that we have on the service, and what can be accommodated in these recommendations. We'll be doing that. Now, it's going to take a while because it's a pretty complicated issue, but we will be in April, at the April Aaron meeting, providing a update where we are. If there's anything that's low-hanging fruit, we'll try to get that out and make additional changes, as we already have. I do expect the UPenn folks should be there. Someone will be there to also present to the Aaron membership, and we'll talk through some of these alternatives at that meeting. If you're not at the Aaron meeting, please definitely jump in remotely, because by then we'll have the first readout from Aaron as to which of these we can look at and which ones might be harder to do. One more thing is that we predominantly worry about the risk. This is a service. It's not really a software. It's not a piece of open source. It's because people are accessing a real-time service. To the extent that this service is used as a way of providing additional security for the routing system, so it's truly optional. Might not be there, might not be available at one point. Aaron actually has very few worries about that. We know how to run high availability systems. The concern is about how many operators turn this on and don't properly do routing validation and rely on this in a way that if the service is unavailable, they do an operational impact. And so we need to have a lot of discussion about that in the community. We did have some on Sunday, but we're really worried about the misuse of the service and what happens when it's not around, not the availability of the service. The availability of the service, we understand we have a responsibility to keep it up and running. Part of the dialogue is also realized we have to get more information out there about expectations and availability so people know what the service commitment is. But really, people think hard about whether or not we can live with the RPI service RPKI service, CA service, turning off. Because if we can, then there's a much lower risk profile if it can be down for 4 hours or 6 hours. And that's what you need to think about, because it's the risk of misuse, people who are impacted who shouldn't be, that has driven the legal protection framework. All right, I look forward to everyone in April participating in this. Thank you.
Well, thank you, John. I think that Aaron has been incredibly constructive in this process. I think that, I appreciate the seriousness with each considering the recommendations. Though I really want to emphasize the meeting on Sunday involved not just Aaron, but representatives from APNIC and RIPE. A lot of those operational questions are not Aaron specific. This is a general community of the support that you're going to receive from the TALs, from all the other RIRs. And so I found that the broader discussion about expectations was actually extraordinarily helpful and important. And thank you for also reminding me we are a team. David Wishnick, who took the lead in much of the work being done here, is in attendance and is here to answer any questions that may come up on that side as well. Please.
Hi, could you go back to your recommendation number 6, please, if possible? Yeah, there you go. This is, I think, one of the most important points that we need to bring up. The two most effective security tools I found over the years are the AUP and the RFP in particular. And this is something that everybody in this room, everybody who is listening remotely, you can go back and you can actually engage in demand generation with your customers to explain to them why they should be going to their providers, including your own organization if you are their providers, and demanding that manners be adopted, that RPKI be adopted, that it be put as a requirement into the RFP. That has the effect of attaching revenue to adoption of these technologies. And it also means that as they become more prevalent, we then see a perceived normalization of risk, which helps lawyers, attorneys in the legal sphere, make a more accurate assessment of the actual risk versus a very abstract risk profile, which we just heard about with the previous commenter. Thank you.
Well, I think that's absolutely true. The procurement can be hard as a requirement. It can be a scoring criterion that's a soft requirement. And there's a lot of different ways to build it in. And especially because something like this, which is actually by tech standards fairly cheap, It's an interesting idea if it gives you a greater likelihood to get business, if not a hard requirement, that itself can make a huge amount of difference. I actually think we owe a huge debt of thanks to AT&T for turning on the service, because it's not just lawyers, but insurers and the other essential parts of the business process need data. And in fact, I'm glad that Nimrod's going to give his lightning talk, because he's going to share with us a little bit of their experience, and we'll find out exactly, be able to get our minds around what the size of that risk is in ways that someone had to be first and take that step, and I'm just grateful to them for doing it, because I think that we all are the beneficiaries of that. Rüdiger.
Rüdiger Volk, Deutsche Telekom. Chris and David, thanks a lot. It's really opening the perspective that the ARIN space actually may get full use, and the benefits of secure routing are not withheld from their members. For John, I would have a question. When you say you want to turn off the service for 4 hours, is it just making the repository server unavailable, or is it, well, okay, for 4 hours everything gets invalid?
So it's an interesting question that we have about failover based on unavailability. Proper caching requirements in practices make sense. But to amplify on something I said last time, one of the leaders of this, for example, have been the Internet Exchange Points in Europe, who have begun treating unsigned routes, as invalid, which is a big step, unless there's They've changed the default policy. You'll have to get the details from someone who knows this better, but to make a more active deployment of RPKI unless there's a specific opt-out. And you start to see things like this where you see broader parts of the community starting to put greater pressure on other parts to begin to deploy RPKI. And I think that is how people who are interested in creating greater security can work together to create that kind of collective dynamic that can actually solve some of the problems that have stopped deployment. So I would encourage all of you to think about this with your organizations as well as to whether you should adopt it and the kinds of things you can do working with your partners to make sure that we make the routing infrastructure as secure as possible. Thank you.